in 2009, when we were all much younger, the WLC was castigated by the state respondents for being too hasty in its approach, alleging that the state had the matter well in hand. The court was told at that stage that the National Executive firmly believed that the Muslim Marriage Draft Bill and the Recognition of Religious Marriages Draft Bill was critical for the well-being of women, and in particular, and society in general. The draft marriage bill itself indicated that statutory recognition of Muslim marriages was required and essential to redress inequities and hardships arising from non-recognition. And so when we launched this application 4 years later, we focused on the rights of those who were socially and economically disadvantaged women, the plight of the poor and the most vulnerable of women. And right at the outset, it bears mentioning, especially given the discourse in the public domain, that the WLC is not a vexatious litigator. It has shown this to numerous courts throughout the country. Its relief sought was not to undermine Islam, it was not to be disrespectful to the Quran, and it wasn't to reform the teachings of the Prophet, which has been referred to in paragraph 11.3 of the State's Heads of Argument. This was a central concern in the High Court. At no stage during the proceedings has there been any suggestion that what is being proposed is that the Quran should be amended in any way. This matter does not involve religious doctrine. No relief of that nature has been sought, and any reliance on doctrinal entanglement is a red herring. The WLC then is now acts in the stead of those very vulnerable class of women and children who suffer these inequities. Its aim was and is to assist all women who could not initiate litigation themselves as an alternative to individual litigation. By bringing a class action, it was the de facto litigant for all such women, and the case properly understood was brought to obtain effective relief for these women. It stated in its finding papers that on average 15% of those who seek their assistance are women with queries directly related to Muslim personal law. It pointed out that the people who came were older women who received little or no education in apartheid South Africa, and formed the termination of the marriage not regulated by law had been or will be devastating. Further, that since the Daniels judgment in 2004, of which the WLC had played an integral role, it was compelled to turn away a significant number of Muslim women seeking help, whom they were not able to assist because of a lack of resources. And that in doing so, it had turned away hundreds of women over the years because it could not assist them. The issues presented by a steady stream of Muslim women who have consulted the WLC since its establishment show that the Muslim community, like many other communities, remain markedly patriarchal, and it is far harder for women than men to receive income, acquire property, and ensure that they and their children are not dependent or homeless if their marriages are dissolved by death or divorce. Such women often enter Muslim marriages without being aware that they do not have the same rights as spouses in civil marriages, and for whom a divorce not regulated by law or have proven to be or willing to be will be devastated. It is not a clear question of a choice, and I will revert to that when we consider the question of the issue of equality. And it is not so. It is also not about Muslims now being afforded an opportunity to register civil marriage under Marriage Act. This still doesn't offer relief to a number of the sector most affected, as recognized by the High Court, and it is not tantamount to recognition of a spouse in a Muslim marriage or Muslim marriage and the consequences flowing therefrom. 27 years later, it's taken us 7 years to reach the apex court. And we can't come back in 11 years' time or 12 years' time. We'd be too old to try and fix what may go wrong. So we need to be sure that the court gives the legislature the appropriate guidance to get it right this time. And up until today, the state respondents have not ameliorated the vulnerability of this class on whom behalf the Women's Legal Center has sought relief. It bears noting that absent from the past 11 years is a complex and necessary process of public debate, government reflection, and legislative enactment, which the state indicated to this court in 2009 would be embarked upon. It represented at that stage that approval by Parliament would be imminent. To date, nothing has been placed before Parliament. Given what the courts have had to say preceding this application and what is contained in previous affidavits before courts, it was incredulous that this application was met in the Court d'Appel with trenchant opposition harnessed by 9 counsel on behalf of the state, with defences amounting to an absolute denial of any breach of fundamental rights whatsoever, despite concessions which had been previously been made.
Ms. Bauer, the 10 minutes is up. You are fair game now.
That's fine.
You may continue.
So a number of these defences that have been raised in the High Court stem from reliance on Papuda, a constitutional free zone in which courts couldn't interfere, a establishment of a fledgling Imam project, a denial that there was a recognition on equality and dignity, and a number of others which you would see from the papers that have been raised. What they then did at the SCA and urged by the Constitution, so it was most appropriate in the context of this, that at the inception of the SCA hearing, the infringement of rights was the first issue on hand, and the state pressed to concede, properly did so in my view, that the infringement of rights of equality, dignity, access to courts and children had been infringed. It's recorded in the SCA.
Sorry, Ms. Bauer, may I interrupt you because you're dealing with the relief now. I'd like to understand, first and foremost, the relief you're seeking in this court. As I see it, you seek confirmation of invalidity as proclaimed by the SCA in its order. Secondly, you seek in the appeal, you seek effective interim relief, as you call it, with retrospective effect. But the question I have is this: I want to understand your conditional cross appeal. If this court is with you in confirming the invalidity as declared by the SCA, do I then understand correctly that you no longer press for the composite relief, in other words, the section 7.2 stroke section 8.1 relief in the composite relief? Because that's a conditional cross appeal. That's what I really want to understand.
That's Justice Majid, it goes back to the manner in which the WLC brought this case. I stood up in the High Court and I stood up in the SCA and I said, because of the people we represent, it mattered not in the relief being given to them, whether the court found it to be under section 7.2 or whether the court found the legislation to be unconstitutional. What we wanted was an effective relief for them. And,
yes, so that then means that if the declaration of invalidity is confirmed by this court, you no longer seek relief that the state must be compelled to enact legislation and so on, the composite relief. Am I correct?
Subject to one caveat, Justice Majid, which seemed to arise from the state's heads of argument, which is not quite clear to us. From paragraphs 10 onwards, there appears to be a recordal in the state's heads of argument of the grounds which they relied on in the High Court as the basis for seeking to say that there was no infringement of the rights. And in the course of this recordal, there seemed to be a limitation imposed on the basis upon which they conceded, they made the concession in the SCA. Now, the concession in the SCA was accepted on good faith, and the SCA recorded in its judgment that the basis upon which that rights infringement was accepted was the grounds as enumerated in the High Court judgment. And so we sit with a concern that if the state is of the view that the concession is only premised on the under-inclusivity of the Marriage Act and the absence of the recognition of polygamous marriages as set out in the heads of argument, we are concerned that in the legislative reform process going forward as contemplated, it may be too narrow to meet the other rights infringements which we have. And if there is that kind of understanding that it is a limited concession, then we fear that in order to give effective relief to our clients, that we would then have to be pressed in asking the court that there should also then be an order under section 7.2 that the state has failed to fulfill, promote respect and promote the rights as contained in the Bill of Rights. But I would only deal with that in reply once we hear what the state's actual position on that is.
Well, that's answer to me is unsatisfactory. It's a yes/no answer. You refer to
Well-
the heads of this. You referred. Sorry, let me just finish. You referred to the submissions of the state from paragraph 10 onwards. But in paragraph 14, they say, despite all these things, they say they accept certain things. And important is in 15, for all these reasons, they do not oppose the confirmation of the order. All I want to know is simply, regardless of what they say, yes, we concede, but it doesn't matter, they concede. If you accept that they do not oppose the confirmation of the order of invalidity, all I want to know is you then do not proceed with a conditional cross appeal because it's good conditional upon that relief not being granted by this court. That's all I want to know.
I would then have to say yes. If the confirmation is on the basis as given by the High Court and the SCA, then that is so.
I don't understand why you say on the basis of the High Court. All they say is they do not oppose what we have here is the SCA has declared certain sections of the Marriage Act and of the Divorce Act unconstitutional. It's incumbent upon this court in terms of the Constitution to confirm that order if it is satisfied that it is correct, that it was correctly made. That's all I want to know. They say they do not oppose that confirmation. Is that not the full answer?
Judge, in order for you to confirm that that is so, you must confirm that essentially what the High Court and the SCA did was that they found that the Marriage Act and the Divorce Act infringe the rights of equality, dignity, children, and access to courts. And underlying that finding on a rights infringement is the basis upon which that is found. Now, if that is not what the state is saying, then there is difficulty going forward. If we are all in agreement that that is so, then I have no difficulty in saying to you that is precisely the position of the WLC, that if you confirm it on that grounds, then we do not require the conditional cross appeal.
Yeah, I'll take it no further. I'll wait for the rest of the argument. Thank you.
Ms. Bauer, in your opening address, you said that the Women's Legal Center does not wish to interfere in any way with the Quran and Muslim law. I have some difficulty. Is it possible to properly regulate Muslim marriages under the Divorce Act and the Marriages Act without denuding Islamic marital procedure? And there we come into freedom of religion. There's two particular aspects I'd like you to consider. The procedure for divorce in terms of the fasq and the talaq. What would happen to that if Muslim marriages are now to be governed as marriages under the Divorce Act and the Marriages Act? That's the first question. The second question, in respect of property, would there be a conflict between Sharia law and what is provided for in terms of the Divorce Act and the Marriages Act? This is now to be particular in respect of whether people are married in community of property or out of community of property, and whether accrual applies. Would that not conflict with Muslim religious law?
So, Judge, let me start this at the beginning to say that if you look at what we've come to court to ask for, we've come to court and say the lack of recognition and the lack of regulation of Muslim marriages is unconstitutional. There are two different ways in which you can actually regulate it. You can do a piecemeal amendments to the Marriage Act and the Divorce Act in order to accommodate it, or you can come and you can do a composite bill to do that. The contents of that legislation doesn't lie in the relief sought by the WLC, and it doesn't lie in the relief granted by this court. That decisions lie with the legislature. Because if you go and you start entering that terrain, then you are in breach of separation of powers in terms of the content of what that legislation should be. There is a breach of rights. Those rights must be acknowledged as being in breach, and how that is fixed and dealt with must be dealt with by the legislature. So when we say that we are not in this court seeking that relief, We are not asking for a court to be interfering with that. And let me say that this is no different to what was asked for by Daniels, what was asked for in Hassam, and what was granted for in Ahmed. That's the first leg of it. On this issue of property, it's the same kind of argument. And there's a distinction to be made in the sense of the following. Sorry? There's a distinction to be made as to whether the Divorce Act and the Marriage Act, right, infringes on the question of property rights. Firstly, we have no regime in the country that determines how property is divided in relation to Muslim marriages. We have a de facto system in which certain remedies are done by ulama bodies, which on their own account and on papers before this court are not able to apply Sharia law because they have no enforcement powers, right? We have the Muslim Assembly who have come to this court and they've essentially said that they encourage Muslims to enter into marriages civilly apart from their Muslim marriages because it's the only kinds of protection they can offer, and the one most akin to what Islamic values require is that of out of community of property. So what you find, and probably the best example I can use is the example of where local authorities in part of what has historically been housing that have been given to families have indicated that the house must be registered in the name of the breadwinner. The Malan case before the Constitutional Court dealt with that issue to some extent, right? So this property that is given to the family is registered into the name of the husband. The husband becomes the owner or the lawful owner of the property. The wife has no rights because they are married in terms of Islamic law, and she has no recourse upon which to exercise any rights in which she's given. She simply has nothing by which she can exhaust anything unless she can create or find some sort of universal partnership. What we are not asking of this court, and that's why I put it into my opening address, we are not asking for this court to delve into doctrine. We are not asking for this court to determine whether the fasakh is constitutional or the talaq is constitutional, or whether it should be in community of property or out of community of property. In that regard, I do accept that for purposes of an interim relief, there is certain relief that is being sought for purposes of ameliorating the rights infringement which this court is faced with.
Yeah, that's going to be my next question, Ms. Bauer. Yes. Doesn't the interim relief somehow conflict with Islamic law?
Well, Judge, that is not the determination for this court to be making. This court is looking at the question of rights infringement. If the legislature is so minded, and the legislature always has an opportunity to legislate and bring into effect a different regime once a court makes interim relief to do that. What you are doing is you are providing an amelioration of the hardships which is being found by the most vulnerable of women and their children in society. You are not in doing that in any way making any determination of what Islamic law has to say, and essentially whether what you are doing conflicts or does not conflict with Islamic law. We are not urging you to enter that domain at all, and for purposes of the relief being sought, you do not have to do that.
Ms. Bauer, is this case not really about the failure of the state to enact legislation to regulate Muslim marriages, rather than the Divorce Act and the Marriages Act being the cause of the alleged rights violations?
Judge, I'm in complete agreement with you. It was the primary basis upon which the Women's Legal Center came to court. It sought its primary relief on that basis. The focus of the case changed when the SCA switched gears on us and wanted the case to be determined on another basis. And I am in this position, Judge, where I cannot but concede that for the constituency that I represent, they will be provided with the relief that they need to ameliorate their vulnerability. But the essence of the difficulty is a failure of the state to respect, promote, fulfill, and there's another word that I've just forgotten in doing that. I maintain that. If the court was inclined to go that way, we have no difficulty in that regard with the argument of the Commission of Gender Equality. It is the argument we made in the court, in the High Court. We are in full agreement with Judge Bokana's judgment in that regard. But I cannot stand before this court and say that the people I represent do not get relief from what is contemplated by the tinkering of the Marriage Act and the Divorce Act. I'm forced to make that concession.
And that was something that the High Court dealt with quite ably.
Judge, it is a fantastic judgment.
But it was not dealt with by the SCA.
Not in any way. The SCA took the view, and I must say, Judge, that I'm now going into my alternative cross-appeal argument, but they do overlap. The argument was a very simple one. You have an obligation under Section 7.2, read with Section 8.1. That obligation is to protect rights. The source of that obligation is not international law. The source of that obligation is the Constitution. This court has said it in My Vote Counts. This court has said it in Glenister. This court has recognized that positive obligation in a very recent judgment in Voko, where you dealt with the high school principal and you said there's positive obligations. On the basis of that positive obligations, you must protect those rights. You have not protected those rights because you haven't brought into effect this national legislation. And that's what's resulted in those infringements. You then leave it open to the legislature to deal with.
Yes. And my final question on this aspect, where does that leave us now? If we have regard to the nature, the fundamental nature of the application brought in the High Court, the High Court's judgment, and then what you refer to as a change of gear in the SCA, where does it leave this court and what we are to do with this application?
Well, I gave that some thought, and I did wonder, Judge. Under Section 172, there is a provision that is peremptory, that if you do find the legislation to be unconstitutional, you must declare it as such. And one would be hard-pressed to say that the Marriage Act and the Divorce Act is not under-inclusive. So the court sits with a predicament that you may, under 172, be compelled to have to declare it to be unconstitutional. But you may provide the legislature with even better guidance if you did adopt the approach of the High Court and say, well, it is also under Section 7.2 and 8.1 where you have that obligation to do so, which is where our alternative cross-appeal comes in. And I'm not shifting from what I said to Justice Majid. I'm saying to you, there is merit to what the Commission on Gender Equality has to say. And in that regard, I am pressed to bring it as a conditional cross-appeal. They are not to do that. And in doing that, you will actually give the legislature probably the kind of direction they need to go into as to actually find a holistic, implementable, and effective solution across the board. Now, the difficulty comes in is that the SCA's problem was that they said, well, if you're compelling Parliament to pass legislation, you are interfering with the separation of powers. Now, this is two sides of the same coin, because at the end of the day, you have to give effective relief. And if you have to give effective relief, and the only relief that can be effective is national legislation, as long as you don't tell Parliament what must be contained in that legislation, it is our respectful submission that that is no different than when you find a section unconstitutional and you send it back and you tell Parliament to fix it up.
Ms. Baba,
You are not.
I'm sorry to interrupt, but you've confused me now, because that is exactly the point that I raised up front. You see, You make clear in your heads at page 39 at paragraph 76, and you say only in the event that this court finds, only in the event that this court finds that the SCA erred in making the declarations of invalidity contained in its order and as a result declines to confirm these orders, only then does the WLC argue that the SCA erred by not upholding the composite relief. And that's the relief in terms of the order of the High Court. So that's why I say the reply you gave me is unsatisfactory, because now it seems that you want to revert to the position before the High Court, and I'm not clear. I mean, you rely on section 172, but what are we to make of a litigant that comes before the court and seeks confirmation, and only in the event that that confirmation is not granted by this court, then is there a conditional cross appeal? So to me, it seems to me you can't straddle two chairs. You must decide what you want before this court, and it really does give me grave difficulty to understand your case.
Justice Majid, I stand by what I said to you as the basis upon which the WLC brought it as a conditional cross appeal, because that is the nature we canvassed our case. My submission to Justice Theron was a response to her question as to, isn't this rather a section 7.2 instance than a confirmation? In an endeavor to assist Justice Theron, I gave the answer. But as the WLC, I can't step away from the case that we had harnessed and had brought. And because we had sought that as alternative relief in our notice of motion, once we got the Part B relief of the unconstitutionality of the Marriage and the Divorce Act, we were compelled to bring it as a conditional cross appeal. The Commission of Gender Equality's case, as I pointed out to Justice Theron, is different. This court can decide whatever case they want to decide. But our case, as I stand before you, is a question of confirmation and a conditional cross appeal. My answer to Justice Theron is a response to her question in an endeavor to assist her in a wide range of different views that is put before the court. And in the course of doing so, mindful of my time, I then endeavored to answer part of my cross appeal on the merits in doing so.
Ms. Bauer, I would like to take you to your relief on interim remedy. You are asking that the order should be retrospective. That will take you to, you say, 1994. I would like to know what is the effect of that insofar as the marriages that have been dissolved either by death or divorce by the talaq. What would happen to those situations?
Justice, we must draw a distinction between the relief. A talaq dissolves a Muslim marriage. We make no bones about that. And so does the fasakh, and so does the khul. The marriage is effectively dissolved. The relief which is then sought under the Divorce Act relates to what is not resolved in that context, which is the proprietary consequences of the marriage and the question of involving children as far as that is regulated under the Divorce Act. Now, one of the difficulties we faced is that in the crafting of the relief by the Supreme Court, they caused a distinction between the existence of the marriage at the time of the order as sort of the line drawn in the sand as to which women can get relief on. And the only exception they make is for women who have, or for litigants who have matters pending at the High Court. Now, the difficulty with that is that, and we went back and we went to check, just about every application that is pending before the High Court, or at this point, let me rephrase that, the plethora of Rule 43 applications, the question of Mrs. Esau, the question of Mrs. Farrell, by the time they come to court, their talaq is through. Their Muslim marriage is terminated. You would have read on the papers that Muslim marriages are terminated on the utterance of the husband, or alternatively, fasakh is granted. So you're invariably going to have an instance of where by the time you come and seek relief in the courts, your talaq has been granted. In fact, Section 5A of the Divorce Act contemplates the parallel existence of a religious marriage and that of a civil marriage. And so when we say we want retrospective relief. We are not seeking to undo the talaq. We are seeking to give women who have been talaq but who have had no other remedy upon which to exhaust legal avenues that had not been available to them before for purposes of getting a just and equitable order as contemplated under Section 7(3) of the Divorce Act that had been available to all other women who had been married since April 1994. And I accept in seeking this relief, probably the most comparative judgment which I've come across is the judgment of AS versus GS that had been handed down in KZN, and I'm not sure if it's been heard by this court for confirmation or it's pending. But the distinction between those who had been married before the Matrimonial Property Act, which is deemed to be out of community of property, and then you have the Matrimonial Property Act, which provides everybody with the protection of in-community of property. And that affected something like, the judgment records 400,000 women. And the Minister of Justice doesn't indicate that there's a disruptive effect. And effectively, the order contemplates that everybody is deemed to be in community of property, and that anybody who wants to be out of community of property can then approach a court. Now, I'm not suggesting that, as you can see from the order. All we're suggesting is that the woman who had under a historical discrimination in this country been denied a relief be afforded an opportunity, if they so wish, to approach a court to get a just and equitable order.
Will that be in that judgment that you referred to? In the order, I think order number 5, we said in terms of section 172(1)(b) of the Constitution, the orders in paragraphs 1 and 2 shall not affect the legal consequences of any act done or omission in relation to a marriage before this order was made. Is that what you are alluding to, or what?
So if you see at 1.8.2 of our proposed draft order, we say it doesn't invalidate the winding up of a deceased estate that has been finalized, or the transfer of property by a partner in the marriage that had been affected, unless that transfer has been to a connected party, or had the person had knowledge, or had been a party to the marriage. We have scenarios in this country where we have polygamous Muslim marriages, whereby one party is a party to a Muslim marriage and a civil marriage. In this country where we have polygamous Muslim marriages, whereby one party is a party to a Muslim marriage and a civil marriage. In this country where we have polygamous Muslim marriages, whereby one party is a party to a Muslim marriage and a civil marriage. In this country where we have polygamous Muslim marriages, whereby one party is a party to a Muslim marriage and a civil marriage. In this country where we have polygamous Muslim marriages, whereby one party is a party to a Muslim marriage and a civil marriage. In this country where we have polygamous Muslim marriages, whereby one party is a party to a Muslim marriage and a civil marriage. In this country where we have polygamous Muslim marriages, whereby one party is a party to a Muslim marriage and a civil marriage. In this country where we have polygamous Muslim marriages, whereby one party is a party to a Muslim marriage and a civil marriage. In this country where we have polygamous Muslim marriages, whereby one party is a party to a Muslim marriage and a civil marriage. In this country where we have polygamous Muslim marriages, whereby one party is a party to a Muslim marriage and a civil marriage. In this country where we have polygamous Muslim marriages, whereby one party is a party to a Muslim marriage and a civil marriage. In this country where we have polygamous Muslim marriages, whereby one party is a party to a Muslim marriage. Argument on all three. First, they said that it was a far-reaching proposal that went beyond what we had sought in the High Court and the Cross Appeal. Now, I concede we didn't ask this relief as to this extent of retrospectivity in the High Court. We didn't think that we were going to be faced with such opposition, that there was going to be a denial of rights, that it would take 7 years for us to get to the apex court. So we had also sought some sort of a different kind of relief premised on the recognition of African customary marriages at the time, which in our wisdom or lack of wisdom, we thought would take care of the problem. But we're now dealing with a lot, in our wisdom or lack of wisdom, we thought would take care of the problem. But we're now dealing with a lot, in our wisdom or lack of wisdom, we thought would take care of the problem. But we're now dealing with a lot, in our wisdom or lack of wisdom, we thought would take care of the problem. But we're now dealing with a lot, in our wisdom or lack of wisdom, we thought would take care of the problem. But we're now dealing with a lot, in our wisdom or lack of wisdom, we thought would take care of the problem. But we're now dealing with a in our wisdom.
Ms. Bauer, I don't know if my sister Justice Mhlanhla is done.
Yeah, that's my last question.
Yeah,
Well,
sorry,
I've
sorry.
got to,
She's responding to my last question.
yes,
all right.
I've got to give her two more answers, Justice Madlanga. The second is that retrospectivity, the court said this is a complex subject and the proposed retrospectivity may have profound unforeseen circumstances. Retrospectivity in cases involving the validity of marriages and the proprietal consequences is not complex and it's not novel. This court repeatedly in the context of customary marriages in Gumede, in Ramahovi, and again the KZN in AS and DS firmly dealt with such matters, recognizing the substantive impact of historical discrimination. In the KZN in AS and DS firmly dealt with such matters, recognizing the substantive impact of historical discrimination. In the KZN in AS and DS firmly dealt with such matters, recognizing the substantive impact of historical discrimination. In the KZN in AS and DS firmly dealt with such matters, recognizing the substantive impact of historical discrimination. In the KZN in AS and DS firmly dealt with such matters, recognizing the substantive impact of historical discrimination. In the KZN in AS and DS firmly dealt with such matters, recognizing the substantive impact of historical discrimination. In the KZN in AS and DS firmly may be recognizing the substantive impact of historical discrimination. In the KZN in AS and DS firmly may be recognizing the substantive impact of historical discrimination. In the KZN in AS and DS firmly may be recognizing the substantive
that I'm going to refer to just now. My sense is that what the WLC is asking for is not different from the type of order that was given in Ramohobi, the type of order that was given in Gumede, and the type of order that my sister Justice Thron told you about just now. The qualification of being the few issues you referred to that are specific to Islam or marriages and Islamic law.
No, Judge. No, Judge. The qualification that we've put into the order is a qualification to answer this response of we cannot undo that which has been which has been done and
No,
gone.
no,
and
no.
affected.
No, that goes exactly to what Ramuhobi and all these other judgments, Kumede and so on have said. Those two have that qualification. So I'm asking that what you are asking for, in the sense that with that inbuilt qualification built into those judgments already, but then the further qualification I'm referring to is you seemed to add something that specifically relates to marriages under Islamic law. Am I making sense? You read what you are asking for to my sister Justice Mhlanhla just now, and it went further than what Kumede, Ramuhobi, and was it Sithole? My sister Justice Throne, I think.
Yes, Justice Mhlanga, it's the third requirement that the transferee was married or had concluded a civil union with the party to the divorce action. In other words,
all I'm asking. Yeah, that's all I'm asking. But
Yes.
the point I'm making, Ms. Bauer, is, are you asking for anything more than what was granted in Kumede, Ramuhobi, Sithole? Are you asking for anything more than that? The exception of qualification or addition merely being what you've just said now. Are you asking for anything more than that or not?
not beyond what is in the draft order we've put before the court, which encapsulate the Ramavoli order. Yes, I think you're correct, Judge.
Yes, all right. No, thank you very much.
Just to follow up on that, Ms. Bauer, if I may, something that concerned me in the phrasing of your interim relief, you refer to where property has been transferred to a person connected to the parties. What does that mean?
It's connected to the party, to the divorce action, Justice Theron. So the reason why we've put it and phrased it like that is what is contemplated is that if we go further up, it contemplates that in 1.8.15, in the case of a husband, is that if we go further up, it contemplates that in 1.8.15, in the case of a husband, is that if we go further up, it contemplates that in 1.8.15, in the case of a husband, is that if we go further up, it contemplates that in 1.8.15, in the case of a husband, is that if we go further up, it contemplates that in 1.8.15, in the case of a husband,